Thank you.
You must have got second.
I am willing to proceed under Chapter 276, Section 58A, and also by agreement to go forward with the hearing. The Commonwealth will be moving forward with the documentation on the papers and the police report, as well as the information relative to the victim's current status.
I do not need any more time. I just would like to know what the status is before we begin.
Sure. So, Judge, there is no stipulation relative to the probable cause, so I am going to read into the facts for probable cause for the basis of the filing to start it off, Your Honor, if I may proceed.
Yes.
Thank you. And for probable cause, I will be summarizing from a Massachusetts State Police Department report of Trooper LeDuc that on the 28th of August, he was assigned to patrol the Andover area from the Andover Barracks. He was operating in a marked unit. Approximately 9 o'clock p.m., another trooper just radioed that informed that there was a rollover crash on Route 213 in Methuen. He cleared from where he was and started to that location. He exited onto 213 and made a turn. He observed fire trucks, ambulances, as well as Methuen police cruisers on scene, and he stopped at exit 3 traveling eastbound. The road conditions were dry. As well, Judge, as far as probable cause, I would read these into the record for the hearing since we are moving forward. Upon exiting his cruiser, he observed Methuen Fire extricating one female patient from the driver's side of a Honda Civic using the jaws of life. He continued down for approximately 500 feet and observed a second motor vehicle, a Ford Escape in the right lane with damage to the hood and undercarriage. A male occupant at that time was outside the vehicle with fresh lacerations on his face and body. The vehicle passenger side rear door was open, and there was a 30-pack of Bud Light on the seat with the top of the case open. Methuen police were alongside this individual inquiring for his name as well as his date of birth. He verbally expressed his name as Stephen Kurelko. This trooper returned to the first motor vehicle and observed a female operator being backboarded by paramedics and into an ambulance and being transported to Lawrence General Hospital at that time. They met with 3 separate witnesses who observed the operation and crash. One, Mr. Nazazian, informed the trooper that his vehicle was involved. His vehicle was later identified as a motor vehicle number 3, which was a Mazda. He informed the trooper that the motor vehicle number 2 was driving, which was the defendant's motor vehicle, at an estimated speed of 100 miles per hour, struck his driver's side mirror, and then impacted with motor vehicle number 2. He explained that the Ford Escape rolled several times eastbound on 213. He walked with the trooper back to motor vehicle number 2 and stood in front of Mr. Kurelko alongside the officer and stated, "That is the man driving and caused this accident." Mr. Kurelko was Mirandaized on the scene. He was placed under arrest. There was 2 other witnesses who would come forward to the officers and would write statements and forward those on to the trooper. There was a recon trooper out for Mass State Police doing an assessment. Mr. Kurelko was transported to Lawrence General Hospital. There were photos taken of this scene. This trooper arrived at Lawrence General Hospital approximately 10:20 with another trooper. He was informed that the defendant was in a specific room, in the emergency room. They determined that the defendant at that time to be Mr. Stephen Kurelko with a specific date of birth. He was being treated by emergency room nurses, and the trooper noted that he was extremely uncooperative, he was unruly, he was shouting extremities to anyone who walked in the area. They were informed as well that the passenger of one of the motor vehicles was also in the emergency room. That passenger was ejected at the scene, recovered by paramedics, and transported to Lawrence General Hospital. That passenger was identified as Mercedes. The other individual who was the operator of Mercedes' car was Mr. Facante. She was being airlifted to Beth Israel Hospital. A second med flight was en route for Mercedes, who was being transported to Tufts Medical Center. Mr. Kurelko was being transported to the MRI section, and he was, at that point, he was in the custody for the OUI, serious bodily injury. He agreed to speak with the trooper and was reminded of his Miranda rights, which were given to him a second time, as well as at roadside. There was another officer that was present, as well as a witness. He stated, he was asked where he was coming from. He stated to the officer that he was coming home from a fantasy football night and going home to Derry, New Hampshire. They asked if he had been drinking. He stated to the officer, "I was drinking Bud Light during the fantasy football. Fantasy football makes me nervous and I wanted to drink." They asked Mr. Kurelko who owned the vehicle. He stated to the officer that he bought the vehicle with his girlfriend. He was cooperative with the officer. He was later brought in for a CAT scan. He started to act unruly again, shouting at the nurses. He had to be reminded to remain still so that they could proceed with medical treatment. He was released from Lawrence General Hospital and transported back to the barracks for booking. He was given all his rights. As indicated, the crash had occurred approximately 4 hours prior to Mr. Kurelko agreeing to take the breathalyzer, which read a .18. At that point, he was informed of the charges again. That would be the probable cause, Judge, and the basis for the filing of the 58A. I am submitting for the hearing not only the facts which were read into the record, Mr. Kurelko's booking information, which lists his residence at 2 Forest Ridge Road in Derry, New Hampshire. However, the complaint reads Manchester, New Hampshire, as well as his occupation, the police report, as well as the Massachusetts crash report for Your Honor's review, which indicates the individuals in the vehicle, Mr. Kurelko being the individual in his vehicle, and 2 other individuals that, who were previously identified that were in the other vehicle, both which were airlifted to Boston hospitals from Lawrence General Hospital. I would also introduce Mr. Kurelko's board of probation record. Which indicates that he has been before the court back in 1997 for operating after revoked license, where he entertained a continuation without a finding, possession of a Class D, back in 96, again for motor vehicle infractions, attaching plates, and an insurance violation, indicating at that point that his home address was Lawrence. If these could, Your Honor, be marked as exhibits. I do not have the photographs or the recon report or the medicals at this time, Judge, but I would introduce the fact that both of these individuals, as stated, were med-flighted, that we did receive information from Mr. Facante that she is off life support at this time, and that the other individual, Miss Sadie, is stable at this point as well, both suffering serious injuries, Judge. Again, I had indicated that charges could change, but at this stage, that's the Commonwealth's presentation for the filing as well as the hearing relative to the 58A. And with that, Judge, I'm asking that the defendant be held without bail, that there is absolutely no way to ensure that this defendant with a bracelet, with a breathalyzer, will not get behind the wheel and do this again. By the time that occurs, these subjects are already gone. This is a serious matter with serious injuries. It will definitely be sent up for indictment review, and more than likely will be indicted based on the injuries, and I'm asking that he be held without.
Attorney Floyd, wish to offer any evidence at this time, or wish to debate on Howard's motion?
First, Your Honor, I would object that the motion can be filed based on this charge. Mr. Kurelko has never been charged with operating under the influence in the past. All of his prior record indicates that his cases have been dismissed, and under the statute, I would suggest that this offense does not qualify under Section 58A, as it is not an offense that by its nature involves a substantial risk that physical force against the person of another could result. As I was suggesting when we were at sidebar, the serious injuries in this case, and I don't in any way want to minimize the serious injuries in this case, but these injuries resulting from an accident could occur in any type of accident, or could not occur in any type of accident. That, by its nature, an accident is just that. It's something that is not planned. These injuries obviously were not planned to happen upon these victims. And as a result, this type of offense is not one that would qualify because by its nature, there is no necessary substantial risk that could result.
What say you to the predicate offense issue, Attorney Floyd?
Judge, I would argue that the OUI with the serious bodily injury is what suffices for the statute. It's or any other felony, which is what Your Honor is dealing with today, a felony that is by its nature involves a substantial risk that physical force against the person of another may result. Doesn't have to result. In this case, it did result. Doesn't have to. And for examples, they state including the crime of burglary and arson, whether or not a person has been placed at risk. Now, this is on the same page as that, Judge, only in this case, people were at risk. He was traveling 100 miles an hour with a BT of a .18. That in and of itself couples with the burglary or the arson. Now, whether he hurt somebody, that throws it over the level for the substantial bodily injury, which makes it a felony. And under the statute, both of these charges, count 1 and count 2, are sufficient. The only thing that I would respond to that is the actual injuries in the case aren't a factor in determining whether it's a predicate offense. Either it is a predicate offense or it's not. It's not a matter of what happened in this specific case that makes it a predicate offense. But that's not the issue, Judge. It's a felony. That's not what the statute reads. It doesn't read whether it is. If it's partially null-prossed down, there's no injuries, but that's not what we're dealing with today, and that's why I asked for the stipulation for the victim's injuries. Those injuries are substantial bodily injury. I mean, 2 individuals, one of them was placed on life support. The other one, I believe, Judge, was in the same condition. Both are off life support at this point and stable, but that makes it the felony, Judge. And with the felony involves a substantial risk that physical force against another. Driving 100 with a .18 in and of itself puts people in substantial risk. Your Honor, but that's not a felony.
Is that a felony?
It's not, but it's the serious bodily injury which we're dealing with today. That makes the statute.
I think the statute says any other felony involving felony. involve a substantial risk that physical force against a person may result.
May result. Doesn't mean it has to, Judge. May result.
But the underlying offense has to be a felony.
Correct, and this didn't become a felony until after
Until the time.
the injuries. So if there had been no injuries, this would not be a felony.
But it doesn't say an underlying offense, Judge. It says a felony by its nature.
No.
This OUI, serious bodily injury, is by nature the felony. And with that falls under the statute.
Any authority for that, Judge?
I don't have case law, Judge, just the statute itself. I don't know if Your Honor has it in front of you.
I just have portions of it that
I apologize, but I've got it.
anything further?
That's it, Judge. I have the statute itself. I don't have case law to back it up. I can provide that to Your Honor if that's what Your Honor is inclined to require for the filing. But my position is that, Paul's position is that it falls within that because it is a felony. It doesn't have to be the underlying charge. Whether it's arson or arson in the burglary, this is OUI, serious bodily injury.
Why don't we brief that? Okay. I want some authority on that. And all right, Attorney Kroll, anything further?
I do have additional information to
Because I'm
provide.
not convinced if that meets
Okay.
the so-called predicate offense threshold for 58. I could be wrong, but I'm just trying to understand the purpose behind the 58A. I'm not sure if that's met here or not. So, yes, Attorney Kroll.
In terms of the other factors relevant to dangerousness, Your Honor, Mr. Kurelko has a job that he's had for 2.5 years. He's been employed at a lumber company in New Hampshire for 2.5 years. He's a warehouse worker. He has worked there in conjunction with his girlfriend, who's present in the courtroom. They've been together for about 4 years. She's been employed at this same lumber company for over 10 years. His job presently is still open. He's using a personal day, essentially, to be here today. And it's a situation where he can return to work if he were released on some kind of conditions. And I would suggest that there are conditions that can absolutely ensure the safety of the individuals in this case and the community at large. He can potentially, with a little bit of time, put together a cash bail in this case. I've been discussing with him and his girlfriend some conditions that could be worked out. The problem is that they live in Derry, New Hampshire. So the conditions of like a bracelet, an Elmo, and the breathalyzer that can be installed on a phone aren't available because they live in New Hampshire. However, his sister does live in Methuen. Her name is Jennifer Blanchard, and he is very close with his sister, and I expect that he would be able to live there in their home. Ms. Blanchard has a son who is 5 years old. His name is Travis, and Mr. Kurelko is very close with his nephew, and his nephew has some developmental issues, and he's very supportive, acts as a father figure because his sister is no longer in a relationship with Travis's father. He also has a similar relationship with his girlfriend's nieces and nephews. He's very close with them and with other family members. He is a graduate of Lawrence Vocational Technical School. He graduated at the top of his class in the construction program. He attempted to go to some college but wasn't able to because of financial aid issues. He's worked prior to this lumber company at Harlex Corporation. He has a history of employment. He has a history of, as you can see from his record, of coming to court. His cases in the past were very minor in nature. They resulted in dismissals, and he was required to pay some fees. He paid those fees, and those cases result from 1996 and 1997. This is a person who is 35 years old and has never in his life been arrested for drinking and driving. And the Commonwealth has obviously shared with the court the serious injuries that have resulted from this accident. But as I said before, this is an accident. And while these two women were injured, and that is absolutely tragic, his behavior did not in any way, anticipate those kind of injuries. Additionally, Your Honor, you have before you the motor vehicle crash report. And I want to be clear, I'm not trying to minimize what happened in this case in any way. But if you look at the report, the crash vehicle report, each individual who was involved in the crash has a section. There's a section for Stephen Kurelko, a section for Robert Nursajan, and for Mr. Kurelko and Mr. Nursajan, there's a section labeled safety system. And Mr. Kurelko was wearing a shoulder and lap belt. And Mr. Nursajan was wearing a shoulder and lap belt. But the two women who were most seriously injured, under their safety system entries, it states that none were used. And I infer that to mean that these two women who were seriously injured were not wearing their seatbelts. And again, I do not want to minimize Mr. Kurelko's actions in this case in any way. But where the Commonwealth is arguing that part of the reason that he is dangerous and that he needs to be held without bail is the resulting injuries. And there is some suggestion from this initial crash report that these two women were not wearing their seatbelts. I think that needs to be factored in to whether or not Mr. Kurelko is a danger. The Commonwealth is going to bring it up that he's so dangerous because their injuries are so bad, then I think the court needs to consider all of the circumstances of how they were injured, and that is a significant circumstance.
Judge, just briefly, it's not only an accident, but for the defendant's conduct. They may have not have been wearing seatbelts, but he absolutely, anybody would anticipate any injuries, especially the ones in Dorothy's when you're traveling 100 miles an hour with a BT of a .18 to get behind the wheel.
I have to object to the continued allegation that he was traveling 100 miles an hour. I've stipulated to the police report, but this is by a layperson, not a police officer, suggesting that he was traveling 100 miles an hour.
Continue this until Wednesday. I want you to check into his situation with Philin, another 12 at any time, and take a fair and comment to brief the issue whether it really applies to the charges in this case.
I will do that, Judge. I would advise the court, I'm not here on Wednesday. Would Your Honor excuse me and allow another to stand in? Thank you.
This officer reflected the non-children.